Good morning, everybody, and welcome to the Wednesday morning seminar with Silver Law. We are continuing this morning the QS series with Conor Ahern, and Conor's going to be talking about subcontracting, named v nominated. As usual, if you have any questions for Conor, please don't hesitate to put them in either the Q&A or the chat facility in the bottom toolbar. Alternatively, if there's something you don't really wish to raise in an open forum, but you do have a question, you can contact Conor on his email address, which is conorahern@silverllp.com, and he will quite happily answer you at his earliest convenience. Right, without any further ado, Conor, I'll hand over to you.
Great, thank you very much, Julie. Good morning, everyone. You're all very welcome to, I suppose, the latest in the QS series. This morning we're talking about subcontracting. Named and nominated seems to be a topic that we get a lot of questions about during various seminars. So, in listening to the masses, we've decided to really focus on the issue in its own individual webinar, which is what we're going to run through this morning. Okay. So look, we're going to get straight into it. So yeah, that's a bit of my profile. And the agenda for today is that we're going to look at a bit of background to subcontracting. I mean, it's a very well-known concept in what we do here in construction, and it's very well understood. So yeah, we won't spend too long on that. We'll go into domestic just briefly, then look at denominated, and I suppose maybe, track through some of the potted history in nominated subcontracting. I guess, where did it originate from, and I guess where is it now is the most important thing. I mean, everything we want to do in these seminars is to bring some relevance into what people are doing on a daily basis. So we'll go through where are we with nominated subcontracting at the moment. We'll look at named subcontracting as well. Obviously it's different concepts to the nominated, but there are similarities. And I think that's where a lot of the confusion, may kick in. So we'll go through that in some detail and really track, I guess, the current position through one of the JCT standard forms in order to give a better understanding of what in fact named means and how it operates. The final area of subcontracting we want to look at is the area of novated subcontractors, because this is a concept that has really caught on, say, I think since the 2011 suite of forms, and it looks to be the way of the future. So we're going to look at novation. What is it? Look, it's a very important case in order, if you're looking at innovation, one really important concept to bear in mind before we wrap it up in the conclusion. So look, that's the plan. So look, we'll get straight into it. Some background into what we're doing here. So obviously, subcontractors required for specialist construction packages. Before projects become increasingly complex, it was common for contractors to employ a large workforce for different elements of the build. Now, that was a very popular concept, going back to the 70s and 80s, where main contractors, in fact, did employ large workforces of their own, and then employed subcontractors to come in and carry out, I suppose, specific pieces of work in order to allow the development of the delivery of the project. Since subcontracting has started to become more and more common, it's been difficult for contractors to employ their own workforces, because now it's a lot easier for just to engage with one specific subcontractor, rather than try and run different parts of a business like a subcontractor and then have to employ other subcontractors in order to fill in the gaps. Nowadays, most main contractors just employ subcontractors and then basically manage the works through their own personnel, or maybe employ their own guys as well, through the likes of what you see on site, the likes of your storemen, gatemen, slingers, other I suppose roles that are needed in the day-to-day running, and which main contractors like to keep some level of control over, rather than handing it all to the subcontractors. So it's just a bit of the, I suppose, the evolution of subcontracting, which is very applicable to the topics of nominated and named that we're looking at today. Subcontractors allow contractors to complete complex projects without accepting unnecessary levels of risk. Look, any main contractor will not, they won't know everything. They will need to rely on subcontractors, especially the specialists, in order to make sure that they're able to deliver, that they understand the program of commercial risk, and ultimately allow them to navigate through a project successfully. One concept that is really important in relation to subcontracting is the area around vicarious liability. Now, this is an important principle in relation to the contractor-subcontractor relationship, and it is actually derived from the normal employer-employee relationship as well. And in the context here, in this case, Lister versus Hesley Hall Limited, there is an explanation of what vicarious liability in fact is. So vicarious liability is indirect liability. It does not involve the attribution of an employee's act to the company. It entails holding that the employee has committed a breach of a tortious duty owed by himself, and that the company, as his employer, is additionally answerable for the employee's tortious act or omission. So what that's saying is that if an employee commits a breach, then the employer is responsible, and that is effectively pretty much the same rule that applies to the role of contractor-subcontractor. Because if the subcontractor commits any breach, then the general rule is that the contractor will be held responsible, and that filters down the line where you have subcontractors as well, sub designers, etc. The party up the line, the party who is engaging, will retain responsibility and find it very difficult to actually to avoid being liable for the actions of their own subcontractors. So it's just an important principle to bear in mind when we discuss subcontracting, because ultimately who is responsible? And generally it is the party just one step up the line that will retain the responsibility for the party lower down the chain, unless it's been agreed otherwise. That is a general rule. Okay, so onto domestic subcontractors. So domestic subcontractors was a common term prior to the JCT 2011 contracts, and in JCT forms now they're just known as a subcontractor. They are now chosen solely at the discretion of the contractor. One question is, does the contractor require the employer's approval to engage a domestic subcontractor? You must check the contract, but the general position is yes. However, obviously, under vicarious liability, the contractor will retain responsibility. JCT forms do say that the contractor is required to seek approval from the employer in order to engage a subcontractor. So just be very careful on the point. I mean, a lot of employers don't take a point on it, but yeah, you just got to be aware that that most standard forms, that is in fact what it says. So just be careful with that. Final point is that most subcontractors are procured in this way. That is true. I mean, most subcontractors are engaged on a domestic basis and are at the discretion of the contractor. The employer has his price, he has his program. By and large, in today's environment, especially where design and build is involved, the employer is happy to let the contractor get on with it and deliver in line with the main contract. That's it. Okay, so now we're going to move on to the nominated subcontractors. So what are they? So they are pre-selected by the employer and then imposed on the contractor. Now, examples of where nominated subcontractors are used. The employer may have worked with the nominated subcontractor previously. The employer may choose the nominated subcontractor if valuable advice or input has been provided at an early stage, and in exchange for that advice or input, the employer has agreed to basically with that specialist contractor to make them a nominated subcontractor and effectively impose them on the contractor once the contractor has been appointed and is procuring their subcontractors. The employer may have to order key materials in advance of appointing a contractor in order to achieve the program. Now that can happen as well. I mean, especially in relation to any specialist items that are that are almost unique to the project, or also can happen in relation to some mechanical and electrical elements as well. So look, so that's the nominated subcontractors. So that's it. That's where they're pre-selected by the employer and imposed on the contractor. Effectively, what they're saying is that the employer is saying to the contractor, you need to basically engage with this subcontractor in order to deliver this particular element of the works. Different approaches in the standard form contracts. Now, in the JCT, I guess the 1918 and even to the 1987 versions, the contractor was entitled to claim an extension of time. However, this did not extend to loss and expense, as confirmed in Norwest Holds Construction versus Cooperative Wholesale Society Limited. Now, in this case, so this is where we start to see, where does the responsibility for the nominated subcontractor lie? And in these standard forms, and as was the decision in Norwest Holds, was the contractor was entitled to claim an extension of time if the nominated subcontractor was late delivering their works. However, the contractor was not entitled to loss and expense for the same breach, effectively. So again, you start to see why there's plenty of confusion around the topic. I mean, you have to. I mean, obviously, in JCT standard forms, not all relevant events which provide entitlement to time transfer or become relevant matters which entitle you to additional money or loss and expense. And it's basically the same distinction here, is that delay by the nominated subcontractor is a relevant event but not a relevant matter, and that is in fact what Norwest Holds Construction decided. In the FIDIC 1999 version, the contractor is not entitled to an additional time or money due to the nominated subcontractor's non-performance. So again, we see the difference in the standard form drafting is that, yeah, the contractor basically, even though the subcontractor is nominated, the contractor retains full responsibility and is not entitled to any additional time or money due to their non-performance. So you can see that the important differences between the various standard form approaches. Obviously, the FIDIC, the FIDIC basis, it means that the contractor has to be very careful in carrying out their due diligence on the nominated subcontractor, and obviously there are grounds in there that if he's not happy to, if for whatever legitimate reason, he may have to object to their appointment, because ultimately, if they fail to perform, he will fail to perform, which will, as a result, delay and cause additional costs. So, when we look at some reasonable grounds for objecting shortly, but in the FIDIC forms, that was a very common topic, and in fact, what it used to do was really delay the process of agreeing the nominated subcontractors, because obviously the contractor had no remedy if they didn't perform, which is almost justifies the JCT position, because I suppose there was somewhat less risk on the contractor because he'd get additional time, which obviously would defend any liquidated damages that may arise due to late completion. I mean, he didn't get his loss and expense, but I think it was a position that most contractors could live with. So it's just different points of view based on different standard forms. Okay, so the development of the law. So in the absence of any clause which expressly permits the contractor to claim time or money, then the risk of a nominated subcontractor lies with the contractor. And again, this came out of Percy Bilton versus Greater London Council. So again, if it's not expressed in the main contract that the contractor is entitled to his additional time or money, then the risk of the nominated subcontractor in that particular case lies with the contractor. So again, you can just see why nominate. You can easily see why nominated subcontractors were causing such wholesale confusion, I guess, at the time. I mean, obviously, I guess with most concepts in construction law, it does come back to what in fact have the parties agreed between them. But you can see the differing approaches that are leading to the confusion, which ultimately has led to nominated subcontractors being largely removed from the current environment. The extent to which the main contractor is liable for the defects of the nominated subcontractor will depend on the precise terms of the contract. So this was the decision in Sinclair versus Woods of Winchester Limited. So that's saying, how is the main contractor liable for the defects of the nominated subcontractor? What they're effectively saying is, you again read the contract to understand, where the responsibility lies and ultimately who is liable. Again, you can see it's just another different approach. Well, effectively what the courts are saying in these decisions is that don't assume that nominated subcontracting is anything. Effectively, it's something, and it's described in your contract, and that's where that's what you have to understand at the beginning. I mean, it does happen, quite a lot actually in construction where, contracts are entered into, but there wouldn't be, normal due diligence would not be as thorough as what it possibly could. And you can see why issues arise where, there's an assumption on the position of a nominated subcontractor, but if that assumption isn't confirmed, or if it's basically rebutted in the contract, well then, the assumption will fall away, and obviously the contract will take preference. So again, it was just another decision that really was the courts trying to say to people, don't assume nominated subcontractors as anything, look at your contracts, which is still a good advice today. So JCT removed the nominated subcontractor option from their 2005 contracts. So, basically, at the time, nominated subcontractors are just causing a significant confusion in the industry. It doesn't seem to be the way forward. I'm not saying JCT decide the rules, obviously, but they do. I mean, they're in a position of persuasion, I guess, that if JCT are removing nominated subcontractors, they're sending a message and doing that basically. So from 2005 onwards, there was no reference to nominated subcontractors, and effectively the reference changed from nominated subs to named subcontractors, which we'll now move on to. So named subcontractors. So named subcontractors, common in JCT intermediate contracts especially. Now, if you're looking at the 2016 suite, look at clause 3.7 in Schedule 2, basically for a pretty comprehensive, I suppose, set of rules that apply to the named subcontractors. So they provide for named subcontractors which may be named in two ways. Now, there's two procedures identified in the intermediate contract. So procedure one is basically where the named subcontractors are included in the bills of quants, the specification, or the work schedules. So basically, it's where it's in the the tender documents for the contractor to see the list of named subcontractors. I mean, again, what's happening here is that rather than imposing one nominated subcontractor, effectively the employer is saying, here is a list of contractors, or here's a list of subcontractors that we want the contractor to consider in order to deliver this particular element of the works. So procedure one is largely pre-contract, is at tender stage before the contract is awarded. Procedure 2 then is, where a named subcontractor is included in an instruction for expenditure of a provisional sum. So basically where the contractor has included a provisional sum within their contract sum analysis, and then the employer post-contract issues an instruction including named subcontractors who basically would saying they're recommending them almost for expenditure or for carrying out that individual piece of work. So the right to object, again, this is again, it's an important principle. So procedure 1, so the pre-contract, if the contractor is unable to enter into a subcontract and provides a good reason, the architect contract administrator issues further instructions. So yeah, so this is where the contractor has used obviously the named subcontractors that were provided in the tender documents, but post contract sees that there's good reason why those named subcontractors may not be suitable, then they're required to ask for further instruction from the architect contract administrator. Procedure 2 is the reasonable right to object is exercisable within 14 days. So if you're instructed to expend a provisional sum post-contract, then the contractor must raise its objections within 14 days. I'm not sure, there's no case law on whether that's a condition precedent, but I think you should treat it as a condition precedent in order to ensure that you don't fall foul of the rule. Otherwise, you could lose your reasonable right to object, which obviously could cause problems, especially based on the responsibility that contractors take for the named subcontractor. So responsibility, once appointed and apart from design liability, the relationship is generally the same as that with a domestic subcontractor. Yeah, so say for the design liability, I mean, with named subcontractors, the relationship is the same as a domestic. So that's basically means we're back to the vicarious liability point, and the contractor is responsible for the performance of the named subcontractor. And if the named subcontractor is late or otherwise does not perform, then the contractor is not entitled to additional time or money. So the design of subcontract work. So the contractor is not responsible to the employer for defects in the named subcontractor's design. The employer will need to obtain suitable warranties or undertakings from the named subcontractor during the tender process. So it's an important principle because what the contractor is saying that if the named subcontractor has carried out some of the design during the tender process, then the contractor is basically will not be responsible for any errors that may be included in that design, which the named subcontractor will have carried out. So the contractor is responsible for supply of goods, materials, and workmanship in the normal way. But what so the carve out is the design element, which is an important principle when we come on to novation later, because novation is effectively seen as a way to impose all obligations on the contractor, including the design of any including the named subcontractor's design. So on to pricing. So procedure 1, the contractor must allow for managing and supervising the execution of the work. So basically, it's the contractor it must allow for that in his tender price. So procedure 2 then is the employer pays the contractor for managing and supervising the work, which can either be pre-agreed or determined on a monthly basis in the contractor's valuations with the QS. So again, if you're including named subcontractors and they've been there pre-contract, the contractor must be making due allowance for managing and supervising. If the named subcontractors are introduced during the works through an instruction, the employer will basically the contractor should track the management and supervision costs. He can agree those up front, or he can have them agreed monthly. So just be aware of the two procedures in relation to in relation to the pricing element. I mean, obviously, procedure 1 will impose larger obligation. You know, it means that the contractor's price must be more thorough. Obviously, procedure 2 is basically, it's almost like a cost plus position for the contractor in relation to his supervision costs, which is not ideal, can end up in a potential area of difference. It's you know, personal experience is that it's always easier to have those items agreed up front, but you know, do be aware that it is a point. So termination. Excuse me. So the contractor must liaise with the architect or contract administrator regarding any potential termination of the named subcontractor. Once the contractor has has basically notified the architect or contract administrator, then the architect or contract administrator then issues instructions for either the contractor to carry out the work, or for the contractor to terminate and appoint an alternative approved domestic subcontractor, or finally they may decide to omit the work from the main contract altogether. The contractor should give notice promptly, and the general position is that the contractor gets an EOT but no loss in expense. The contractor must use reasonable endeavours to recover costs from the terminated subcontractor. So yeah, so if the contractor feels that that he may need to terminate the named subcontractor, he's required to give notice promptly. Obviously, it's a key difference between a named subcontractor and a domestic subcontractor, because with the domestic subcontractor, basically the contractor will see that something is going wrong, and they'll take steps on their own to decide how best to deal with the issue in order to mitigate any potential future loss or delay. So the contractor here with the named subcontractor gives his notice promptly, and as I said, the general position is he gets time but no money. The contractor must use reasonable endeavours to recover costs. So again, I mean, if the named subcontractor, has just not taken their subcontract obligations responsibly, then the contractor is required. I mean, that's where he can potentially recover any loss and expense or consequential costs that the contractor incurs as a result of the subcontractor's non-performance. Now, that obviously becomes difficult if we're talking about a situation where the named subcontractor is effectively insolvent. I mean, that would make it difficult. I mean, the contractor will almost, need to apply under the insolvency procedure in order to recover the costs, but obviously not ideal, especially obviously from the contractor's point of view. So yeah, so if there is termination coming, the contractor can get EOT from the employer and basically required to use reasonable endeavours to get any money from the named subcontractor directly. So that's all, that's the remedy. Again, nice distinction with normal domestic subcontractors, and even previously, with nominated subcontractors. To be fair, in the JCT, in the JCT clause 3.7 and schedule 2 of the intermediate contract, it's quite clear on the rules, and they are very helpful. So if you do need further information on that, I'd suggest just walking through the JCT clauses. They are quite detailed and specific as to how the various responsibilities are deployed. Okay, so we've talked about grounds for objection in relation to nominated subcontractors, and also in relation to named subcontractors. So obviously this is where the contractor is concerned about the subcontractor's ability to deliver, and the most common grounds for the main contractor to reject or object to the named subcontractor is first ground is lack of subcontract resources. So whilst the contractor is basically in dialogue with the subcontractor, may realize that the subcontractor simply does not have adequate resources to carry out the work, or they may be very busy on other projects. They may have issues on other projects as well, which basically means that they won't be able to give the contractor's project its due attention. So that's one of the grounds for objecting. Have they got experience in similar type work? I mean, you would expect any named subcontractor to be, I guess, experienced in the particular package that they're being recommended for. I mean, obviously, if they're not, I mean, obviously, if you've got a lift contractor being recommended for a groundworks package, I mean, obviously, you're going to have very clear grounds to object in such circumstances. So, it is expected that, that the employer and the employer's professional team will have carried out their own due diligence and ensure that, that named subcontractor has got the experience and the know-how to deliver that named subcontractor package. So next one is financial strength. So, the contractor may do his due diligence on the named subcontractor and see that, the named subcontractor in effect has got very low financial reserves. I mean, it may not have a balance sheet, it may have very little cash, and all of these issues, so obviously the main contractor will be concerned about the named subcontractor's ability to deliver the project, which is obviously very important, because as we were saying earlier, especially in relation to a named subcontractor, the contractor is required to recover his loss and expense. He can't get his loss and expense from the employer. He has to pursue it from the named subcontractor. And I mean, if the named subcontractor is insolvent, effectively, the contractor is going to be in a very difficult position trying to recover any of his costs associated with any potential future insolvency. So, a very, very important ground for the contractor, and the contractor absolutely must do his own due diligence to ensure that the named subcontractor has adequate financial reserves in order to be able to deliver the project. Finally, then, another common one is that the subcontractor may refuse to indemnify the contractor for any negligence. This is probably one, I think the first three are clear, but this is probably the one that probably causes the most conflict, I expect, because the subcontractor refuses to indemnify the contractor for his negligence. Again, that can become a real bone of contention. Obviously, that's the contractor wants that to protect himself. And if it's like another guarantee to the contractor that the subcontractor will perform effectively. But a lot of subcontractors won't like giving it, and it's going to become a key area for objection and discussion around objection. If the subcontractor is refusing to provide it, you'll have the contractor, especially if it's under procedure 1 and pre-contract, the contractor will be saying that we're not comfortable entering into this named subcontract because these named subcontract won't give us the assurances that we're looking for. So again, it's probably one of the more controversial ones, but there'll be a lot of dialogue around that if it is a genuine issue. If the objection is rejected by the employer, then the contractor should seek an indemnity from the employer. So that's basically that. That should be if the objection is rejected by the named subcontractor, then what the contractor will then seek is an indemnity from the employer itself. Again, so what the contractor is effectively doing is ousting the general rule. It doesn't want to go through the procedure where it's got to recover the costs from the subcontractor. They obviously want an indemnity from the employer, which is quite difficult. I mean, not many employers give out indemnities. So again, you can see where there can be much dialogue around the grounds for objection, and why the contractor wants the assurances that the work can be delivered either down the line from the subcontractor or up the line from the employer. Okay, so we're going to move on to the final section, and this relates to novated subcontractors. Okay, excuse me. So part of the design and build model which is now prevalent. So Nominated Subcontractors is, if you look at any design and build contracts now, they do cater for novation. So what this does is it allows the employer to engage a specialist subcontractor and then to novate them across to the main contractor. This is quite popular. I've seen this on large, I guess large contracts here in London, I guess, where basically the employer engages a specialist subcontractor. Now that can be to carry out the enabling works, to carry out demolition, to carry out structural alterations, to carry out any of those early work packages that that the employer obviously wants to commence early, and in the meantime basically develop its design for what the project will look like later on, and basically a lot of the reason is to allow its design team to get ahead of the design, which obviously will be required in order to appoint a main contractor at a later date. Idea being is that they would then have the information to allow the main contractor to price the project with more certainty, and basically what will happen then is that once the main contractor is appointed, they will novate the subcontractor, the early work subcontractor, across to the contractor. It's become a very popular method of procurement, which I can only see continuing as the trend. So there's excuse me, there's effectively two types of novation. So the first one is ab initio, and this means that the contractual history is restructured to give the impression that the subcontractor has worked for the contractor throughout the project. So this basically means that that the subcontractor is novated to the contractor, and that he has always worked for the contractor. That's effectively what the ab initio means. Whereas the switch looks like the original agreement between the employer and subcontractor terminates, resulting in a new agreement between the contractor and the subcontractor. So there's subtleties within this, but the switch basically shows that that the original agreement between the employer and the subcontractor terminates, and effectively the contractor and the subcontractor take forward a contractual relationship from under a new appointment from the point when the the original agreement is terminated. So yeah, so two concepts that are very important to understand when you are interpreting your novated your deeds of novation effectively, which always should be included as part of your your contract documentation, which we're going to come on to now. Excuse me. So novation is a tripartite agreement between the parties, with both the benefits and the burdens of a contract are transferred. So I tried to demonstrate this in a very basic diagram, but you can see employer, subcontractor, contractor. So that's showing the two contracts that the employer is entered into, is basically involved with. But following the novation agreement, it's restructured, and the employer engages the contractor, who engages the subcontractor. So it removes it basically ends the original contract between the employer and the subcontractor. So the novation requires consent. The obligation to novate and deed of novation should be included in the subcontract issued by the employer, and also in the main contract issued by the employer as well. This makes it clear that it is the employer's intention to novate, and it's always better to have the form of words there from the outset rather than introducing it at a later date, as it can cause a whole myriad of issues in relation to objections from the main contractor later. So yeah, just key advice for for the employer is that have the obligation to novate and the deed of novation included in the main contract and the subcontract. Very, very important. Okay, key issue in relation to novation, which I guess is somewhat sounding one of the alarm bells with novation, and one of the issues that you have to be careful with, and it's in relation to, I guess, what's known as the black hole when dealing with novation. Very important case on this is the issue is Blythe and Blythe versus Carillion, and it goes back to 2001. So you can see novation as a concept is, albeit it's become more prevalent today. It's been around for quite some time, but it's it's obviously starting. It's evolving continuously. But this is a very important case to bear in mind when you are looking at novation. So in this case, the employer, which was THI Leisure, appointed Blythe and Blythe as the project engineers. While employed by the employer, Blythe and Blythe prepared the technical information for the tenders to be used to engage the building contractor, and underestimated the amount of steel reinforcement required in the works. So Blythe and Blythe basically appointed by the employer, but they basically underestimate the amount of steel reinforcement required. The underestimated figure was included in the bills and the building contractor's tender, and subsequently incorporated into the building contract. Obviously, Carillion relied on those, I guess, estimates from Blythe and Blythe, which were part of the contract sum, which obviously formed part of Carillion's ultimate contract. Under the deed of appointment, Blythe and Blythe were required to enter into a deed of novation with Carillion. So inaccuracies or deficiencies were contained in the pre-tender information prepared by Blythe and Blythe. Carillion relied on the information in tendering for the building contract, and after such inaccuracies were discovered, it incurred extra costs which it sought to recover from Blythe and Blythe. So obviously, the estimates are realised during the construction phase, and which results in Carillion spending additional money, and it's seeking to recover that from Blythe and Blythe. So Carillion claimed from Blythe and Blythe that had breached their contractual duties owed to the employer THI under the deed of appointment, which occurred before the date of the novation agreement, i.e. Carillion were seeking to recover losses in relation to the pre-novation breaches. So the court held that Carillion did not have the right to recover such losses based on an alleged breach of duty by Blythe and Blythe committed prior to the date of novation in relation to duties then owed to THI. So basically the court is saying that as Blythe and Blythe committed the breaches before Carillion, before the novation, Blythe and Blythe, Carillion can't recover those breaches. So the court's reasoning by decision was that as Carillion were engaged in a fixed price building contract, and as THI had suffered no loss as a result of the inaccuracies of the consultant's pre-tender information, Carillion could not, by virtue of the novation, claim for such losses. Now, obviously, you can see that that's quite a difficult position for Carillion, but you can understand the logic, and it's still a logic that does apply, to novation, and this relates to novation, be it novation under the main contract, novation under subcontract, whatever the case may be. You've got to be very careful about the wording to understand, I guess, where the parties' obligations start and finish, and also if you're in Carillion's situation as to whether the original subcontractor or designer owes you any duties for any work they carried out directly for the employer before the novation. Also, key concept to really understand. So on a proper construction of the novation agreement, the contractor could not claim for its own losses caused by breaches by the engineer, which were prior to the date of novation in relation to the duties then owed by the engineer to the employer. The losses sought by the contractor were not being losses conceived as having been suffered by the employer. Novation does not retrospectively change obligations that have already been performed. Consequently, contractors need to protect themselves with appropriate contractual conditions where they are taking over the responsibility of the design by way of innovation. They may also consider entering into collateral warranties with design teams to protect themselves from pre-innovation losses, and that is one of the ways in which a contractor can get collateral warranties from the design team or from subcontractors for any of the work carried out pre-innovation, which will obviously create the contract link to make it easier for the contractor to pursue the designer or the subcontractor for any breaches committed pre-novation. Yeah, this is kind of where we are. This is where novation, we're seeing it more. It's a lot more prevalent these days when we're drafting contracts. Then especially nominated subcontractors and the named subcontractors as well, for that matter. So yeah, so that's pretty much whistle stop tour on novation, and one of the key issues to watch out for when you are dealing with novation. So we'll just summarize now. So we looked at domestic subcontractors, obviously the most popular form and the one everybody is very familiar with if you're dealing with any construction project. Nominated, you could see I guess where the confusion used to arise with nominated subcontractors in relation to whether the contractor was entitled to loss and expense and or extensions of time. It was basically, there was no one, there was no general rule at all. It always came back to the terms of the contract, is basically what the courts were saying. Named subcontractors, yeah, so that's where a list, a few names is provided by the by the employer who they want the contractor to consider using. It's still popular. It does happen, especially in the intermediate forms. And as I said earlier, it's worth reading those clauses, clause 3.7 and Schedule 2, just to really understand what the process is and how it should be administered. Finally, we looked at the novated subcontractors, and as I said, this kind of brings us up to date, because we see the novated subcontracting as a route is definitely the most popular of these options of the obviously it's not more popular than the domestic, but it would take preference over named and nominated today, which has been my experience, and just bringing you up to date on that and the issues to watch out for if you are dealing with any novated subcontractors. Okay, look, we're going to wrap it up there. Thanks for listening in, and I'm sure Julie will be happy to deal with some questions.
Absolutely, I'll certainly ask you them. I will not be answering them.
I was hoping you'd answer them as well.
No, you're not getting away that easily, Mr. Ahern. Okay, first question up. Is that only applicable if the design is done before tender? If it's CDP, would the contractor then be responsible for the design? Obviously, going back to an earlier point you made.
Yeah, is that only applicable if the design is done before tender? I'm unsure about which of the, what was the status of the subcontractor. It looks like the timing on it might have been in relation to the named subcontractor. If you're dealing with the named subcontractor, basically the carve out for design is that I'm sure the subcontractor, is it only applicable if design is done before tender? It largely would. I mean, it would, because we were dealing with option one, and that was dealing with design, pre-construction elements. So, the carve out on the design would be would be the named subcontractor's responsibility. If it's CDP, would the contractor then be responsible for design? Can be the case. Again, I suppose a lot of the message around this was to check the contract to see where the responsibilities lie. Obviously, generally with CDP, the contractor is required to carry out their own investigations in relation to the information provided to price the CDP elements, and following that, the contractor retains responsibility for CDP items. So if it's a CDP item that a named subcontractor is feeding into, then there would be an obligation on the contractor to check out that design in order to ensure that it was accurate or that it was sufficient in order for the contractor to price and program the CDP elements. If it's not, then he should be allowing a contingency, but obviously the contingency can be difficult if the contractor is in a competitive tender, especially on a single stage basis. Obviously he's got to try and get as much contingency as he can in, but unfortunately it's likely to be limited by commercial realities in a competitive in a competitive tender environment. So yeah, so that's as much as I can offer on that, Julie.
Okay, what happens if the tender inquiry doesn't include a list but a single named contractor?
Doesn't include a list. I mean, if it doesn't include a list, what happens is that the contractor can add names. I mean, and you know, JCT does provide that the contractor can add names to the list, and basically is basically saying that these other subcontractors are equally qualified as the one name that as the contractor that you've named on the list also. And basically, you know, what the contractor at that stage is required to do is, you know, complete their due diligence on all of the subcontractors and decide, you know, which one is going to be the, you know, the best fit for the project. I mean, it could very well be that the contractor decides to engage with the one name provided, but again, he's got to do the due diligence to get to the right answer here, in order to, you know, in order to be comfortable with the risk that he's required to accept under the main contract. I mean, that's really the position, and obviously with the named subcontractors, there is that flexibility that the contractor can add names to the list, whereas you didn't have that before with nominated subcontractors. Effectively, the subcontractor was being imposed on you by the employer. The named subcontractors does allow for the contractor to add names to the list and then go forward and go through the procurement process and due diligence, as it does with its own domestic subcontractors as well. Okay.
Okay, similar sort of question here. Under JCT IFC, named subcontractors using option 1, again, only one offered by the client as a specialist ground remediation specialist, following extensive negotiations by the client and the subcontractor pre-contract. Is this not nomination, irrespective of the description of named, given no possible commercially viable alternative?
Yeah, look, very good question. You've only been given, you know, you're only given one specialist, you know, ground remediation contractor. You know, the employer is saying that they're a named subcontractor. They're not nominated. Obviously, they're doing that because they don't want to retain responsibility for their performance. You know, so, you know, effectively, you know, almost in theory, it's pointing towards the nomination, but obviously the words are, you know, the contract will say that they are named. And if you're not given any commercially viable alternative, I mean, you've got to be careful in the due diligence process, especially to, you know, to seek the indemnities, like I was talking about under the grounds to object. I mean, seek the indemnity down the line from the subcontractor. You know, in the event of you know, of non-performance, perhaps they could, I don't know, perhaps there could be other different potential means of security introduced, perhaps like a performance bond or something like that from the specialist, from the ground remediation specialist, which will help to protect the contractor's position in the event of any default, because obviously the bond premium will then be called upon in the event of non-performance. Similarly, the main contractor could seek an indemnity from the employer, or other means of assurance that basically, you know, to protect the main contractor's position, that they're not getting, you know, they're not being left with all of the liability on this one individual subcontractor, which it looks like is key to the overall delivery of the project. You know, the main contractor's got to be very careful in his due diligence here, because you know, if he's not, he can be left, you know, picking up all the responsibility, which obviously is unattractive for any main contractor. So, look, I take the point. It is effectively a nomination, because you've basically saying that you've no other viable alternative, but the main contractor's got to stand up and negotiate, you know, the terms and seek to get whatever protection, and I guess be creative in the circumstances as well. As to what reassurances they can get to protect themselves in this situation.
Okay.
Yeah.
In a term contract, if novation of design subcontractors or design consultants supposes consent, does a term in that contract saying novation is to occur, excuse me, pass the test for consent given, pass the test for consent given that the subcontractors or designers might be parties unknown at the inception of the contract?
Yeah.
Question
Again, it
there.
depends. Again, it depends on you know, it depends, I guess, on the wording of the consent. I mean, you know, like obviously there's different wording. Like some of it might just be giving notice to the contractor that the novation is required. You know, what I was saying earlier is that if you can at all be more specific than that, if you know that there's an novation coming, and I think it's always a good idea to include the deed of novation as part of the contract documents. I say that because from experience, it's always easier to get agreement on such documents at pre-contract stage. If you award the contract to a contractor, and you're trying to introduce concepts or documents later on, it's just rife for objection, and it's going to make life very difficult. If you try to introduce new documents afterwards, it's always better. It's like saying, you know, why do we include the collateral warranties in contracts pre-contract? It's because from experience, again, if you say that you've got to provide a collateral warranty later on and you introduce the words after, 99% of the time there's going to be an objection to the words. So again, you're always better off to just, you know, go that extra mile in the pre-contract documentation to obviously include the novation clause, state that it's your intention to do that. Obviously, you're not going to know the main contractor at that stage, but like you're just going to, you know, put in any potential third party that, you know, becomes clear and obvious at a later date. But the novation clause should be drafted clearly, and as I said, you should always try to include the actual deed of novation itself, just to avoid, you know, drawn out, you know, negotiations and correspondence on the issue at a later date. So look, that's my advice there.
Okay. Final question here is someone saying they have a main contractor who is unable to sort out the payment terms to comply with the main contract payment terms with this named subcontractor, and has argued that it is down to the employer to sort out the payment terms for the named subcon, since the named subcon was chosen by the employer before the main contractor came on board. Has the employer any grounds to reject this argument?
Yeah, I mean, again, it does depend on the terms of the contract here. I mean, the employer, like named subcontractors, like this is that's the employer basically identifying some subcontractors potentially that could be suitable for the project. I mean, it's not imposing on, you know, the subcontractors on you, like, you know, in the same way as the nominated position used to. So there is a degree of, you know, there is a degree of flexibility around named subcontractors. And as I was saying earlier, like the main contractor can introduce other names to the list of named subcontractors as well, if that's what they want to do. But I don't see it that, you know, that the employer will be responsible for actually agreeing the payment terms, the payment, like for the employer to agree the payment terms that will exist between the named subcontractor and the main contractor. I don't see that as, you know, I don't see that as a responsibility for the, you know, for the employer. I think it's something that, you know, should be raised as part of the objections by the main contractor if the named subcontractor is being unreasonable, or he's looking for, you know, 7-day payments. And you know, the reason why he could be looking for 7-day payments is because he doesn't have any money. You know, so the main contractor's got to do the due diligence to see, well, what is the position? You know, why does this named subcontractor want such favorable payment terms? And I mean, as I was saying earlier, the you know, the concern about the financial stability of any named subcontractor is grounds for objection. And if you can't agree, you don't. Then you got, you know, if you and it's going to continue to be an issue. Then you know, then you move on and use another named subcontractor. You know, that's the thing.
Yeah.
You have options with named subcontractors, but I think in the circumstances described here, I think the employer has ground to reject the argument, because I don't see it, unless the wording of the contract is specific. I don't see it as it would be the employer's duty to agree the payment terms between the main contractor and the named subcontractor. I'd struggle to arrive at that conclusion here. So, final answer, I guess, is that yes, I would see that the employer has valid grounds to reject the argument. Okay.
Okay. As usual with legal, you've taken a long time to get around to the yes or no.
Yeah.
Okay, that
really
seems to be all of our questions today. So thanks as always, Conor. Really interesting seminar there. Lots of information. Your next one will be next month, I believe, the next in the QS series.
Yes.
And I think we're talking about, is it payment security next month?
Yeah.
I believe. Yeah. I know concurrent delay next month.
Concurrent delay. Yeah.
Concurrent delay. That's favourite topic.
Yes.
So if anyone would like a place on that, please email seminars@silverllp.com and we'll happily book you on. In the meantime, we have one more today, which is this evening at 6 p.m. That's with Richard Silver, which is Construction Essentials, where he's talking about loss, expense and damages. So if you would like a space for that and you haven't already booked, again, seminars@silverllp.com and I'll get you booked in for that. So, Conor, thank you again for your time. Thank you, everyone, for joining us this morning. Hope everyone has a great day. Weather looks to be fabulous. So enjoy, everybody, and we'll see you all again soon. Thanks, Conor.
Great. Thanks, Julie. Thanks, everyone. Have a good day.